Yeah. What is it, Groundhog Day again?
No, it's National Lipstick Day.
National what?
Lipstick Day.
Lipstick.
Mm-hmm.
I didn't know we had such a day.
Oh, yeah. Brenda, are you ready to go on the record?
I'm ready.
All right, the court is going to call 2019 CR 10448, State of Texas versus Christopher Saxon. Can I have parties announced for the record for the state?
Michael Villarreal, Michelle Hayden from the state. Nathan Slimane and Valerie Headland from Jack.
All right, and for the record, Mr. Saxon is here. Have both parties had a, oh, please be seated. Have both parties had a chance to review the jury charge?
Yes.
State,
Yes, Your Honor.
defense?
Yes, Your Honor.
Any objections, state,
No, Your Honor.
defense?
No, Your Honor.
All right, so my understanding is that each party is requesting 30 minutes. Is that correct?
That's correct.
All right, so defense, I'm sorry, state, you said yesterday you're going to break up your time with 10 minutes and 20 minutes.
Yes, Judge.
All right, any time warnings for anyone?
Judge, maybe just, if I've got 2 minutes left, I don't think my closing will take that long, but I don't want
Okay.
to run into Michael's time. So 2 minutes.
All right, and then defense, are you breaking yours up?
Judge, we're not going to break it up. If I could just know when I have 10 minutes and 2 minutes.
10 minutes and 2 minutes. Okay.
And-
Yes,
I anticipate I won't get this morning, but can you let me know if I have 5 minutes left?
all right. See, now that people have said they don't anticipate them needing a warning, I predict people are going to need warnings, but that's okay. And honestly, if some of you go a little bit over, I will not stop you.
Yes, Judge.
But if it's an extra 30 minutes, then, you know,
If it's 30 minutes, club me on the head and drag me.
okay. All right.
You want that on the?
No.
So then we're gonna bring the jury in if the jury's all here. Brenda, I do hope nobody's spending millions of dollars trying to win $1 billion and
Did
then
you see that,
taking out loans.
the Cane's Chicken CEO bought,
Yes.
was it $550,000 worth? Gave a ticket to each employee.
Mhm.
What?
But then he
So,
said,
But if they win, what happens?
I thought they had to share.
I know, but they have to share it.
Why?
No, I think he like gave each person an individual thing.
I think that's nice, though. I mean, that money could probably be spent other ways, but
Right.
supporting your employees.
Well, honestly,
So
I
what
think
about-
I would have preferred not have the money that you spent on my ticket. But I guess it's only $2.
I don't even know if there's a dollar in it. It's revenue, maybe much.
Mhm.
$1.50.
Well, if they say someone in San Antonio won, I guess we'll all be.
They're all here, Judge.
All right, thank you. Let's bring them in. Brenda, would you be one of those people who held your ticket to the last possible minute?
To go turn it in?
No. For me, they'd say it's too soon. All right, everyone, please be seated. You have really moved around. Happy Friday. All right, so I'm going to read to you the jury charge, or what's called the charge of court. You will be given a copy of it to take back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Christopher Saxon, stands charged by indictment with the offense of felony assault against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship alleged to have been committed on or about the 11th day of June 2019 in Bexar County, Texas. The defendant has pleaded not guilty. 1, Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. Our law provides that a person commits the offense of felony assault if the person intentionally, knowingly, or recklessly causes bodily injury to a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship, and if the defendant has been previously convicted of the offense of assault against a member of the defendant's family, household, or a person with whom he has or has had a dating relationship. 2, for purposes of the offense of felony assault as defined in paragraph 1 above, you are instructed that a defendant has been previously convicted of the offense of assault against a member of the defendant's family, household, or person with whom he has or has had a dating relationship if the defendant was adjudged guilty of the offense or entered a plea of guilty or nolo contendere in return for a grant of deferred adjudication, regardless of whether the sentence for the offense was ever imposed or whether the sentence was probated and the defendant was subsequently discharged from community supervision. 3, bodily injury means physical pain, illness, or any impairment of physical condition. Family includes individuals related because they share a common ancestor, without regard to whether those individuals reside together, individuals who are married to each other, individuals who are former spouses of each other, and individuals who are the parents of the same child without regard to marriage. Household means a unit composed of persons living together in the same dwelling without regard to whether they are related to each other. Dating relationship means a relationship between individuals who have or have had a continuing relationship of a romantic or intimate nature. The existence of such a relationship shall be determined based on consideration of 1, the length of a relationship, 2, the nature of the relationship, and 3, the frequency and type of interaction between the persons involved in the relationship. A casual acquaintanceship or ordinary fraternization in a business or social context does not constitute a dating relationship. 4, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscience, objective, or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of, but consciously disregards, a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. With respect to the evidence admitted in this case concerning the defendants having been previously convicted of an offense against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship, if he was, you are instructed that such evidence cannot be considered by you as in any manner proving or tending to prove that the defendant intentionally, knowingly, or recklessly caused bodily injury to Melissa Saxon, a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship on or about the 11th day of June 2019. 5, now if you find from the evidence beyond a reasonable doubt that on or about the 11th day of June 2019 in Bexar County, Texas, the defendant, Christopher Saxon, did intentionally, knowingly, or recklessly cause bodily injury to Melissa Saxon, a member of Christopher Saxon's family, household, or a person with whom Christopher Saxon has or has had a dating relationship by striking Melissa Saxon with the hand of Christopher Saxon, and before the commission of the offense alleged above on the 21st day of September 2017 and cause number 550680 in Bexar County, Texas, the defendant Christopher Saxon was convicted of the offense of assault bodily injury married, an offense against a member of Christopher Saxon's family, household, or a person with whom Christopher Saxon has or has had a dating relationship, then you will find the defendant guilty of felony assault against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship as charged in the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. You are instructed that under our law, voluntary intoxication does not constitute a defense to the commission of a crime. For the purpose of this law, intoxication means a disturbance of mental or physical capacity resulting from the voluntary introduction of any substance into the body. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Written or recorded statements made by witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After you have retired to your jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by signing the same as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them. But they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you ever retire to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the bailiff. Any communication relative to this case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. And just one moment, could I see both parties, please?
the law that the judge just gave you, it sounds like a pretty complicated charge, but when you break it down, it's really not. And you'll have it in the back with you. And some of the evidence in the case, defense will present their closing argument, and then Michael will get into the evidence in more detail. So the elements are what the state has to prove in. That's the only thing that you guys are here to answer. You're not here to dissect an 18-year relationship. You're not here to really question what went on the day before, the day after. It's limited to the elements of the offense. So again, what we have to prove and what we've proven to you, and a lot of these elements really aren't in context, but on or about June 11th, 2019, pretty straightforward, we know the date, in Bexar County, Texas. Melissa gave you that address, it's in San Antonio. Again, not contested. The defendant, Christopher Saxon, he's been ID'd, you have the pictures of him. Intentionally or knowingly or recklessly cause bodily injury, pain, to Melissa Saxon, a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship, by striking Melissa Saxon with the hand of the defendant. And on September 21st, 2017, in cause number 550680, the defendant was convicted of the offense of assault bodily injury married, an offense against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship. And I highlight the word "or" in there because you guys just have to be unanimous to your verdict. So if 4 of you go back there and say, I think he intended to cause her pain by swinging his arm and hitting her. And 4 of you say, well, he knew that he could cause her pain by doing that. And 4 of you say, well, he's been drinking, he swings his arm, he's reckless about it. That's fine. It doesn't matter how you reach your verdict, just that you're unanimous that 1 through 8 has been met. So I'm going to break down some of those elements in a little more detail directly from your charge. Bodily injury means physical pain, illness, or the impairment of any physical condition. Now, in voir dire, all of you guys said, we don't need photographs, we don't need medical records. And medical records aren't going to tell you if someone felt pain. Only that person can tell you if they felt pain. And you guys saw the video. He's much bigger than her. He swings his arm hard, you hear her reaction, and you've got the pictures. Pain is all you need. This isn't an aggravated assault case where we've got to cause serious bodily injury. We don't even have to prove that the pain lasted. All you need is pain. Family, and again, in the element, it doesn't matter if you think it's a member of the family or household or a prior dating relationship or both, but again, I broke down this instruction for you. So family includes individuals related because they share a common ancestor without regard to whether those individuals reside together, individuals who are married to each other, individuals who are former spouses of each other, which is what we have here, former spouses, pretty clear, and individuals who are parents of the same child without regard to marriage. And then dating relationship means a relationship between individuals who have or have had a continuing relationship of a romantic or intimate nature. So under both definitions, these 2 people apply. But again, if 4 of you say, I think they had a prior dating relationship, 4 of you say they were former spouses, and 4 of you say both, it doesn't matter, just that you're unanimous. Next thing I want to talk about, because this is also something that defense spent some time discussing, is purposes of a conviction. And Detective Soto broke it down for you, just the way that the code is written, but just for clarification, and you have this with you, you are instructed that the defendant has been previously convicted of the offense of assault against a member of the defendant's family, household, or a person with whom he has or has had a dating relationship if the defendant was adjudged guilty of the offense or entered a plea of guilty or nolo contendere, which you've got this judgment in front of you. You can look at it, nolo contendere. In return for a grant of deferred adjudication, you guys can see this at the top here. You can go back and look at it. Regardless of whether the sentence for the offense was ever imposed or whether the sentence was probated and the defendant subsequently charged from community supervision. It doesn't matter what happened to him after this, you guys have the judgment. And again, Bobby Segovia linked up the judgment to the information in this case, which just gives you details of who the complainant is. He linked him up to the fingerprint. Pretty straightforward. So the evidence that you have in this case, and you can take it all back there and look with you. You heard the testimony from the witness stand from Melissa Saxon. You also have her statement, which is defense exhibit 1. And it's been 3 years since this offense. If she doesn't remember perfectly what went on earlier in the day, it doesn't matter. What she's consistent about and what matters is the assault. And you guys saw it for yourselves, you heard it for yourselves, you heard it from the witness stand. That is what's important. Then you heard from Detective Soto, and you heard from the fingerprint examiner, Bobby Segovia. You've got the ring video footage that you can go back there and watch. And it's short, you know. Feel free to watch it a couple times if you want to. And that ring video footage, as I want to point out, defendant was at her house. She's not trying to get him in trouble. She's not following him around, recording her with his cell phone. He went to her house, uninvited that night, and smacks her. And you've got the photographs in the case. You've got the photographs where he throws his phone at the wall. Got the photograph of her injury. And you've got the photographs of him showing no injury. 2 different dates. He's got what appears to be a pimple or a mole or a little mark on his face. Not an injury. There's been no evidence that he was injured. And then you've got the judgment and the information and the drop cards, which you can go back there and review as well. And defendants talked in their voir dire about common sense. And ladies and gentlemen, you can use your common sense at arriving at what beyond a reasonable doubt means to you and what happened in this case. And what's reasonable. This case is straightforward. You can trust what you saw in the video, you can trust what you heard on the witness stand. We've proven our case to you beyond a reasonable doubt. Now, in your jury instruction, you also are instructed not to let bias, sympathy, or prejudice play any role in your verdict. So you can't go back there and say, you know what, I feel sorry for him. I think he had a drinking problem. This wouldn't have happened otherwise. Like, I'm going to give him a break for that. Or you can't go back there and say, you know what, I didn't really like the complainant, so I'm going to give him a break for that. That is not for you to decide. Only the elements in this case are what you are here. We've proven our case to you. Again, it's straightforward. We ask that you return a verdict of guilty. Thank you.
All right, defense.
Thank you, Judge. Ladies and gentlemen, in a few minutes, you're going to go away and deliberate. And when you go and do that, each of you is going to have exactly 3 jobs to do. The first job that you're going to do is to have a discussion about the weight and the credibility of the evidence you actually received. The second job you're going to have is to make sure that you actually follow your oath as a juror and that you follow the law that the judge gave you. Again, this is not a law of opinion. This is a court of law. Lastly, you need to have a discussion with one another about why you feel the way you feel about the evidence in this case. You need to make a decision in this case if you can. If you can't, that's okay too. Your oath is not an oath that you're all going to come to the same decision. That's not what's required. There's 12 of you. That means that we're going to have 12 verdicts. It's okay if they're not all the same. You will not have to explain to anyone why you decided to do what you did. I'm going to say something else very important. Each of you, your work is done here the minute you decide that some reasonable doubt exists to maybe even one of the elements of the offense. I'm going to say that again. Your work is done the minute you decide there's some reason for doubt. Now, folks, we're all here for the truth, and I want you to think about the truth as like a big jigsaw puzzle. It's made up of a whole bunch of pieces. And you put them all together and you get a big picture. And that whole picture, that entire picture, that's the truth. Now, the state, in their burden of presenting this case to you, they get to decide what pieces of the puzzle they want to show you. They get to decide what pictures, what pieces of evidence they want to present to you. They also get to decide what pieces of evidence they don't want to show you. What pieces of the whole truth they don't want you to do. Now, folks, the prosecutors in this case have put a tremendous burden on them. They're asking you to find this man, stand up, Chris. They're asking you to find this, a 23-year veteran law enforcement officer guilty of a felony. A felony. Sit down. A felony. This is a district court. This former law enforcement officer is sitting at the same table as murderers and killers and drug dealers, the same people. This guy spent 23 years of his life protecting you all.
Your Honor, I'm gonna object at this point. It's irrelevant and it's outside the proper scope.
All right, ladies and gentlemen, the jury, you've heard the evidence in this case. Does everyone understand? All right, you may proceed.
He's sitting for the first time at a table and they're asking you to ruin his life based on what they decided to show you and what they decided to not show you. By making a felony. Now, when you go back and talk to each other, I want you to ask each other, did they show you enough credible evidence to find him guilty beyond a reasonable doubt? I'm going to talk about that too. To find him guilty. Now, the first witness was who? Latent fingerprint examiner. He was here to show up what? That 5 years ago, Christopher had a misdemeanor case that was an allegation of an assault against Melissa. Did he actually assault her before? Did he actually cause an injury before? We don't know. Part of the puzzle, they decided not to show you. Wouldn't you like to know that? That's the reason we're in the felony court, because of what may have happened before. Wouldn't you like to know if there actually was an assault that took place? It doesn't matter. And the reason why is ultimately the case is dismissed. He was
Your Honor, I
not
object.
found.
That's not in that.
That is absolutely an evidence, Your Honor.
All right, that
was-
objection will be sustained. Ladies and gentlemen, the jury, you've heard the evidence in this case, and you're to base your decision upon the evidence that you've heard. Does everyone understand? All right,
The state presented no evidence at all about what happened. None. Could they have? Sure. They chose not to. But again, that's not what's really important in this case, and that's not what we spend a lot of time talking about. I want to talk about the second witness, Melissa Saxon. When you deliberate, I want you to ask each other, did you think she was credible? Why? Why not? Now, you saw several times when the prosecutor was going up here and asking Melissa questions, showing her documents, showing her photographs, asking her questions. And she was responding to his answers, looking at the documents, looking at the pictures. And then, when it was my turn to confront her with her own prior statement, all of a sudden, her vision was. She can't see. The state just brought up the issue about the little dot on Chris's face. And I'm going to tell you right now, that question, that was not about trying to point out that there was an injury to Chris's face. After she said she couldn't see that paper, I asked Melissa, does Chris still have that little red dot on his face today? Or what she said, no, zits come and go. From all the way over here to all the way over there, she has no problem, provision's good enough. Oh, yeah, there's no blue dot. Can you look at your statement again? No, my vision's bad. Does that help her credibility? When her recollection of what happened, what she said, changes, when all of a sudden she's being confronted by something she said that goes against what she's saying now. Is that credible? Credible enough to win his life? Folks, the key to credibility is consistency. Let's talk about some of the other things she testified about how that day. She said, I didn't know Chris mentioned it. He let himself in. Then that sort of changed. We all heard it. He forced his way in. Then she changed her story again when presented with her earlier statement. Well, I opened the door so he could come in. Inconsistent. She said he was not welcome in the house and he knew he was not supposed to be there. I asked her, then why did she open the door if she knows he's not welcome there, but she doesn't want him there? Remember her response? I don't recall. Then you heard her change her story when confronted with that same earlier statement. And admitted, yeah, Chris did have belongings there. While she was in Austin, she knew he was in the house. That was her testimony. She knew he was there. He was actually welcome there during the day, but quote, she would like him to not be there at the house by the time she got home. Inconsistent. Her testimony kept changing from one thing to another to finally, I can't remember. I don't recall. Folks, if she can't recall, you can't convict. She said she even had mixed feelings about being here. The state had to subpoena her. She didn't want to be here. She wasn't sure. Why? Is it because she really doesn't remember? Is it because maybe she still loves Chris and hopes that they'll reconcile again? Or is it because she understands? She read the language of that subpoena. She knows what can happen if she doesn't show up to court, that she can go to jail. Or that if she gives false testimony on the stand, what happens? She can go to jail. Well, she changed her story more than that. Changed the tide of sweeping. It was not consistent. It was not credible. Let's talk about the real elephant in that video. Now, I'm going to be very honest with you. The first time I watched that video, bothered me a bit. Bothered me a lot. And I'll tell you why. It's startling to hear somebody shriek. When I was in college, I spent years volunteering in the University Hospital emergency. That was the last time I heard somebody shriek in jail. That's the type of shriek and wail I would hear when the doctor is telling somebody they're sorry their loved one is fine. It's startling to hear that. But a scream, it's not a song. A wail is not unusual. So I watched the video again and again. And then I watched it again last night after hearing Melissa's testimony. And something about the video really started to not make sense to me. It bothered me. I don't want to talk about this. Now, Melissa had testified she's got a lot of experience with that green book. She has an app, she's got it set up, she knows that she gets notified when there's activity at the door. She decided where to post it, up in the tree. She knew the microphone was recording sound, she testified. And most important, when there's motion near the door, it triggers the camera to start recording. And I thought, wait a minute. Here's what's bothering me. When the video starts, the doors. Did y'all catch that? When the video starts, the door's already open. What else? Chris's stuff. His laundry basket. It's already sitting there in the doorway. motion triggers the video. So let's reason through that. If motion is what triggers the camera to turn on. And we know that there's motion before the door, right? The door's already open. The basket's already there. And we know that that motion is not on the video. It doesn't show the door opening. It doesn't show how his basket is stuffed out there. There's only one logical conclusion. And that is that the video you're being shown is not the complete video. That's the only logical conclusion. Something else happened before. So if it's incomplete, that means what? It's been edited. By whom? By Melissa? I don't know. Who's the only person the prosecutors called to testify that that video is authentic and complete? Melissa. Who's the only person they brought to you to show this video has not been tampered with? That this is the entire recording, despite the fact that the door's already open, the basket's already there, and that's where the video is going to start. Not when it started before, not when Chris and I are at the door before. We're going to leave that part out. Who's the only person they brought to show this is the whole video? Melissa. What else happened? Something else happened. The state has the burden. She has the burden to bring this to you. What else happened? We don't know. If she edited, why didn't she want the police to see what happened? You know what they said? A half truth is a whole lie. Folks, I want you to watch the video again during your deliberation. I want you to watch it for a lot of reasons. And another reason I want you to watch it is because it is crystal clear that when that video starts, Chris is trying to leave. The door is open. His stuff is out there. He's trying to leave. She's struggling with him at the door. She doesn't want him to go. He couldn't wait to get out of it. The minute he was outside, he's like, I'm leaving my stuff here. I'm gone. I'm out of here. The state wanted to also talk to Melissa about something he said to her. I didn't think it's relevant. But she said, Chris called me a stupid effing B. That's true, he did. Now, ordinarily, I'd say, so what? Who hasn't called somebody a name when they're upset? It's not illegal. It's not nice. But I want you to listen to him say it again. He's not angry when he's saying. He's not saying, you stupid effing B. How does he say it? Listen to his tone. He says, you stupid effing B. He's like, you're being ridiculous. That's his tone. You're being ridiculous. Folks, he's had enough. He's had enough of the crazy. He's had enough of the drama. He's had enough of the loneliness. He's had enough of the failed reconciliations. The divorce petition, drop, reconcile. Divorce petition, drop, reconcile. Divorce petition. It's finally done. She testified the divorce was finally done right before this happened. And he was walking out of her life finally and forever, and she couldn't handle it. Something else interesting about that shriek when you listen to it. This is just something I observed, maybe it means nothing to you. But when I heard it on my computer first time, I flinched. Chris is supposedly a couple feet away from her when he hears it. He doesn't even flinch. Not even a little flinch. Why not? Is it because he's so used to hearing the screaming and the wailing, the drama, that he just doesn't even react to it anymore? Or is it because there was no scream at the time? If the video was edited, Was that scream in there at the time? I don't know. We don't know. All we have is lists. So let's talk about the next element, and this is the one I think they're doing. Bodily injury. Now, the state brought you some photographs. And they asked Melissa, what is your injury? Here's this picture, State's Exhibit 4. And they asked her, what is your injury? The state can't ask you to speculate what her injuries are or might be. She testified. And what did she say? The injury is some redness here on her cheek. What else did she say? Chris is bigger than her. He's almost twice her size. He's a cop for 23 years. He's been trained using physical force. He's got a half metal hand. And she said, he knows how to throw a punch. She said yesterday that he backhanded her so hard, it knocked her off her feet. That was her statement. It knocked her off her feet. 165-pound person knocked backwards off their feet from being hit by a metal hand to her face, backhanded. No abrasions, no swelling, no broken skin, no black eye, no bleeding, not even a scratch. Not even a scratch. She said, there's some redness here. Is there? I don't see any redness. The only redness I see here is on her ear. And she agreed. The reddest part of her skin is her ear. He also said he didn't touch her ear. So what are we supposed to believe? Beyond a reasonable doubt, that this guy, a cop for 23 years, bigger than her, stronger than her, knows how to throw a punch, has metal plate in his hand, punched her so hard in her face, knocked her off her feet, and it didn't even make her cheek red as her ear. Is that a bodily injury? Did it hurt? Yes, it hurt. Does the video show her getting knocked backwards off her feet? Does it? Watch it. Does it show her getting knocked backwards like she testified? Or does it show her just like dropping to the ground? Like an
10
emotional,
minutes.
thank you, Jeff. Like an emotional flop, like we see soccer players do when they're trying to drop down. All right, folks. I said that the state gets to decide what pieces of evidence they want to show you and what pieces they don't. They hold all the cards. And in deciding what they want to bring you and deciding what they don't want to bring you, it's like deciding what cards they want to play and what cards they don't. So we know what they brought you. We've gone over all of it. Let's talk about what, based on the testimony, we know they could have brought you and didn't. Now, Melissa testified, she called 911 a few times, at least more than once during the day. But they didn't give me 911 calls to listen to. Melissa said the police came to the house. But they didn't call those officers to testify. They didn't come and ask them, what did you see? What did you see? Did Chris seem drunk? Did he seem impaired or intoxicated? Did they do any examinations of her face? Did they make any statements on the body cam? Chris or Melissa? They chose not to play that game. Melissa said there are at least 2 other ring videos that would have shown Chris coming and going, and would have helped us all know what version of her story is what actually happened. And she said, I didn't think to bring those. Melissa said she had bruises that appeared the following day. But they didn't bring any pictures. Were there actually bruises? Was there any testimony about anybody who saw bruises on her face? Maybe that's reasonable doubt for you, Mr. Hartman. Melissa said she went to the doctor, but he didn't give any medical records. No record of any injuries at all. Did she even go to the doctor? I don't know. Perhaps that's reasonable doubt for you, Mr. Hartman. Melissa said the ring video showed the entire interaction between her and Chris. But based on her testimony about the camera being triggered by motion, we have good reason to believe that's not true. What else happened? We can't know. Perhaps that's reasonable doubt for you, Mr. Witnesses. The detective Soto testified Chris had given a videotape interview that night to law enforcement, and that Chris had repeatedly denied assaulting Melissa, who was recorded, but they decided not to play it for him. Why not? Because that's reasonable doubt for you, Mr. Garrett. Melissa testified that Chris was drunk that night, and he was an angry drunk. Detective Soto, when I questioned him, asked, did he appear intoxicated to you? Were there signs of alcohol? What did he say? He said, I heard that's what the wife was saying, but that was my observation. Does that help Melissa's credibility when a trained law enforcement officer is challenging for account? Does that create reasonable doubt? This is another thing that's very interesting to me. And I'm going to ask Valerie to please come up here a little bit. Melissa testified under oath that Chris backhanded her. But he backhanded her with the palm side of his right hand, and that the injury was to the left side of her face. But she was standing to the right. So I'm just wondering how that is even possible that he backhanded her to the right side of her face, left side of her face, with the palm of his hand. It doesn't make sense. If he's backhanded and she's to the right, where's the injury going to be? Right side of the face.
5 minutes.
Thank you. Thank you. I don't know. Something else I thought was interesting. She testified yesterday that she last hung out with him a month ago. Not a month after this happened, a month ago from today. A month ago, she's still going by his work, bringing him his mail, asking him to get her a bottle of water, complaining that I went to work in the store, he just didn't want his job. Probably still hoping that there's still some chance of reconciliation. Her name, after all these years, is still SAXON. She even testified they don't have any kids. They've been divorced for years. Still haven't changed her name. I bet she talked to me. Let me have some slides. Folks, all we can consider, all you're allowed to consider is the evidence that the state has brought you. You can't guess, you can't surmise, you can't go off gut feelings. You have to go by the testimony, and the photographs, and the video. That's it. Not what I say, not what the state says. Now, they have the only burden. They have to prove that he's guilty beyond a reasonable doubt of every element of the offense. If they fail to do so, your oath, your duty under the law means to acquit, to find him not guilty. How sure must you be to convict? Let's talk about the burdens of proof. The very bottom, innocent. Let's go, highly unlikely. Reasonable suspicion, that's what's required for law enforcement to make an arrest. When the police come and decide they're gonna take you to jail, reasonable suspicion that a crime is concerned, that's all it takes. Next is probable cause. Preponderance of evidence, more likely than not. This is the standard that's used in civil trials. Some of you said that you've been on civil juries before. Just talking about money. We're talking about somebody's life. Clear and convincing. This is the standard that's used in CPS and family courts. If there's a motion or an action to try to terminate somebody's rights as a parent and keep their children away, the evidence has to be so clear and convincing that it's the only right thing to do. Beyond that, probably guilty, but maybe some doubt. Maybe. Finally, guilt beyond a reasonable doubt. If your decisions, your deliberations, your discussion of the credibility of the evidence about what was not presented makes you put you at any of these levels other than beyond reasonable doubt, your duty under the law is to find Chris not guilty. It's not maybe guilty. It's not probably guilty. It's not possibly guilty. It's not he could have done it. There's three possibilities which you can come back with. You can say guilty if they proved every element beyond a reasonable doubt. You can say not guilty if they didn't. Or you can say, I'm not sure. That's okay. You don't have to all agree. Some of you might say, I've already made up my mind before you got up here and started talking. Some of you might say, I'm confused. I just can't make up my mind. That's okay. That's okay. The verdict is for them to convince you maybe they didn't do it. It's okay to say you can't make up your mind. Again, there's 12 jurors. Your oath is not to go back there and all agree. It's okay to disagree. There's 12 of you. If you all agree, that's unanimous. That's fine. Okay? No verdict is okay. You're not taking oaths to swear to agree. We're asking you to find Chris not guilty. And I will argue that at best, when considering everything that they brought to you, but they didn't bring to you, that they have failed to prove this case beyond a reasonable doubt, sufficient to convict him of a felony, possibly lock him away. But they did succeed in this. Creating doubts. This is not a rock solid case, folks. This is just a basket of dirty laundry. You should abandon it on the ground and walk away from it, just like Chris did in the video. I'm going to say this again because I think it's very important. Maybe guilty also means not guilty. Any reasonable doubt means not guilty. We are not suggesting, as the state mentioned, aliens came down from outer space and possessed Chris's body. Folks, your work is done. Each of you, your work is done the minute you decide that there may be some reasonable doubt or that it might exist. Any reasonable doubt means that you must render the jury not guilty. Confident reason who was right. It's fair. You're going to find Christopher not guilty.
Good morning, ladies and gentlemen. So I want to talk with you a little bit about the state's case and just also talk about some of the arguments made by defense counsel in this case. So these are the elements that the state has to prove to you beyond a reasonable doubt. On or about June 11th, 2019, Christopher Saxon, the defendant intentionally, knowingly, or recklessly caused bodily injury to Melissa Saxon, who is a defendant, a member of the defendant's family household, or who the defendant had a dating relationship with, by striking Melissa Saxon with the hand of the defendant, and that he's been previously convicted of this offense. So, a lot of these elements are not in context here, even based on what I'm understanding of the defense argument, right? So that's not really a question. Nobody's questioning in June 11, 2019. There is no question that this is Christopher Saxon, right? Intentionally or knowingly or recklessly. Not really in context here, right? Defense spent a lot of time talking about bodily injuries. I'm going to cover that in a second. Melissa Saxon. There's no question that the person who took the stand was Melissa Saxon. That is the defendant's ex-wife. At the time of his previous conviction, she was the defendant's wife. By striking the complaint with the hand of the defendant, we spent a lot of time talking about against Christopher Saxon, symbiotic man with a metal arm. You look at him, he's flesh and bone like the rest of the people. But there's really no question based on the video and what I'm understanding of the defense's argument that hit her in the face, right? And before the commission of this offense, he was previously convicted of a assault bodily injury. As it relates to that one, it's not really a contest, I don't think, based on his argument, but you have the judgments, from the order of court adjudication and the information. He wants to tell you that, well, did he really previously assault her? Did he cause her bodily injury previously? Yeah, it's in safety exhibit number 3. This is what he was convicted of by intentionally, knowingly, or recklessly causing bodily injury to Melissa Saxon. It's in evidence. Okay, so that argument has no bearing. Well, the state didn't tell you what happened with the case. Yes, we did, because we have to prove what happened with the case. He was convicted because he was placed on deferred adjudication. Here is the order showing that he was on deferred adjudication for assaulting Melissa Saxon. State's exhibit number 2. So, really not a contest there. He's not contesting what's in here. He's just trying to make an argument that's not based on it. So, bodily injury. This is in the charge of the court. Bodily injury means physical pain, illness, or any impairment of physical condition. Does it say bodily injury means bruising? No. Does it say bodily injury means the state has to put on medical records? No. Bodily injury means physical pain. She testified that it hurt when she was hit, right? Pain is enough, so long as you believe that she felt pain. Okay. What do we know from Melissa Saxon's testimony? Testified to cause pain. She said she saw stars, knocked her off of her feet, and that bruising developed the next day. We all have bruising, pretty sure, right? How many times have we been knocked our knee on something? Probably me, most likely walking around the bed in the morning, hit our knee on it, and we don't get anything until the next day, right? We have some bruising on our leg, right? That's how bruising works. It's not like as soon as you get punched, all of a sudden you're going to be black and blue in the face. Also, if you go back and watch the video, which I'm going to show you the video again, you can hear the smack, right? It's reasonable to infer when you hear that noise and hitting her in the face that it hurt. What's to make a big deal about safety exhibits numbers, I believe 7, 8, 9, and 10, which are the photos that we introduced her as she looked at them. Didn't want to hide anything from the jury, so we're going to show you what she looked like that. One thing we can agree on, doesn't really show too much, right? But I don't have to show you a visible injury for you to believe that there was pain in her body. So, just going through the sequence, we have Bobby Segovia, who printed the defendant. We went through the effort of going through the prints, showing you that I printed this man today. These are the, when he was booked on this case, those are the prints from when he was booked on this case. They're the same prints. This is the same Christopher Saxon that we're talking about. So this is his conviction, right? So that's how we introduce cases in number 2 for you. We have Melissa Saxon. So she gave you a testimony of what happened that day. I agree. She doesn't have the best recollection of what was going on before this happened, before he came back to the house. Even if you look at defendant's exhibit number 1, which you can recall, we have no objection. We want him in. Normally these things don't come in, but we don't want anything to be hidden from you. Look at her statement as it relates to that 10 o'clock p.m. He came back to the house, right? They wasn't making a big deal. He was there at the house earlier in the day. So I don't recall, right? What is it? What does it disprove as far as the state's elements are concerned? Does it disprove that it happened on a certain date? That was him, that he struck her in the face and caused bodily injury to her? That was his ex-wife, that he's been previously convicted of it? Does that disprove any of those things? No. It's been 3 years. It's understandable she might have the best recollection. Who cares if she was in Austin earlier in the day? Who cares if he was in the hospital? When she got home, he wasn't at home. Also, see the video. I'll go ahead and play it for you again. What do we notice about that video? Number 1, he's already walking out of the house, and what does he do? He turns back around, right? He could have just left, but what does he do? He turns back around and he back. You can hear the hit, you can hear the smack. Now, Mr. Slimane wants Ms. Headland to come up here and say, oh, it was with the open hand. I don't remember any testimony about open hand. She's gonna, it wasn't a fist.
I'm gonna object to mischaracterizing her testimony. She absolutely said it was an open hand. It was a call.
All right, ladies and gentlemen of the jury, you will remember the evidence as you received it.
Back hand's pretty clear, right? Is it the back hand? No, back hand. Backhanded her. If she's facing this way, it's coming back around. What side of the face is he gonna hit? Left side. Okay. Pretty obvious. He wants to make a big deal about the screaming. She's dramatic. All those things. Even if it's true, that's true. What is that? What does that change, right? Does it change that she got hit in the face? Does it cause her pain when it happens? No. Right? So you also have her written statement. There's some discrepancies about what happened before the assault, right? Where she was, where he was. But if you look at the thing, there's not really any discrepancies when he returns to the house and when she doesn't want him to, right? That's not like she invited him over. The thing talked a little bit about, Melissa Saxon. We subpoenaed her to be here, and she was hesitant to be here because she wants to reconcile. But also, she's so vindictive that she fabricated a story of assault that's also corroborated by a video, an objective video. Well, which one is it? She wants to get back with him, or she's lying to get back at him? The picture's worth 1,000 words. This video is worth a conviction. This is really, and I'm not going to missay our position, but it's a very important part of the state's evidence in this case. It's objective. It tells you what happens. It shows you clearly. You're able to view it, and it shows it's smacking her in the head. And then Detective Soto. The reason that we brought him for you is to show that Mr. Saxon, what does he do? Denies. And then when he's confronted with the video, all of a sudden he doesn't remember, right? I never assaulted her. But when he knows that there's objective evidence in this case, he can't continue to deny. So what's his only other option? Some convenient amnesia. So, that's what we brought Detective Soder for. Is also to show that he didn't observe any injuries on the defendant. There's no prior assault that happened. He's not hurt or anything like that. So, this is in your charge as well. Statements of counsel made during the course of the trial, during the argument, not supported by evidence or statements of the law made by counsel, if not in harmony with the law stated to you by the court in these instructions, are to be fully disregarded. What does that mean? It means what I tell you, what Mr. Spomane tells you, is not evidence. These are arguments. So when he tries to argue facts not in evidence, that's not for something for you to consider. Look through all the things that, where are you gonna find it? The case was dismissed. I don't think that. You argue things that are not. His opening statement talked a lot about the number of things. I can't even recall about how many things, but none of it is supported by the evidence, right? You are to look at the evidence in this case. Take that evidence and apply the law that has been given to you by the court, and then reach a verdict. So, if he said something, or even if I said something that is not in evidence, you're to disregard those. Ultimately, the state has proven this case to you beyond a reasonable doubt. Each and every element beyond a reasonable doubt. Really, what Mr. Spomane wants to do is put some cards in here and say, well, this is reasonable doubt. This is, oh, we didn't bring you medical records. Okay, there's not a single element up there that says the state proves, must prove to you beyond reasonable doubt through medical records, right? None of it. Well, the state didn't bring the cops that initially reported to do what? To tell you what she said. We brought her to tell you what she said. Well, we don't have the videos earlier. Okay, he was at the house earlier. So does that disprove any of the state's elements? No. So I'm confident in this case that you're going to reach the correct verdict. And that verdict is guilty. And so once you retire, spend time going through that and we are on your time. We're just asking you to reach the unanimous verdict. I know that defense counsel spent a lot of time saying it's okay if you don't reach the verdict. But at the end of the day, I believe that you will. Because the state's evidence is very clear in this case. There's nothing that presented to you that can credibly disprove any of the elements of this case. So we're asking that you retire to the jury room, look over the evidence, and find the defendant guilty. Thank you.
All right, ladies and gentlemen, I keep telling you, I will let you know when you can deliberate. You now are going to be retired back to the jury room, but I'm going to need Mr. Gonzalez and Mr. Alamy stay behind, please. All right, everyone, please rise for the jurors. All right, everyone, please be seated. So we're going to await the jury's verdict. Counsels, just make sure that the coordinator, the clerks have your contact information if you decide